See, good morning.
Good morning.
Good morning. Let's see. You are here on DF 1816789.
That's correct, Judge.
Okay. Let's see. And do you represent is it Calixtro? How do you say it?
Michael, yeah, Mike. I think it's Calixtro. He's here. He can correct if it's. I think it's Calixtro. Yeah.
Okay. All right. And I see that he's here. He's on mute. And good morning, Mr. Is it Calixtro?
Yes, Calixtro.
Okay, good. I got it right on the first time.
Yes.
All right. All right. So it looks like we're just waiting on Miss Calixtro and her attorney.
I don't believe she's. Well, I don't believe she's retained an attorney on this. She has one, and we have a modification going on too. But last time I talked to her attorney, she wasn't retained on the enforcement.
Oh, okay. So let me just check some things out here to see where we're at. My computer just decided to start working this morning on the bench.
Well, it's better late than never.
Oh yeah, I was streaming from Chambers, but it's so bright in there, with all the windows. So I'm glad that I'm back on the bench. Let's see. All right, so she was served. I just want to make sure.
Yeah, I believe 11 days ago.
Okay. So what we'll do is I'll give her 10 minutes to see if she appears, and I'll have my bailiff call the hall to see if she's here in person for any reason. And we'll just proceed from there.
Okay.
All right, thank you.
All right, thanks, Judge.
Yeah, meet me.
Okay. Okay, we're going to go ahead and go on the record. Okay, we're on the record in cause number DF 1816789. Counsel, would you please state your name for the record?
Justin Ewert for Michael Calixtro.
Okay, and we are also streaming live on YouTube in compliance with the Texas Open Courts Act. The courtroom is also open for people to come in and watch as well. The hall was called by my bailiff at approximately 11:13 a.m. The respondent, Melissa Calixtro, although served with, in order to appear to be present today, she did not appear and therefore will be in default. She is also not present on the Zoom. So, Mr. Calixtro, did you want to continue with your hearing or did you want to reset your case?
Continue, ma'am.
Okay. All right. So is it Ewert, Mr. Ewert?
Ewert, perfect.
Okay, great. All right. Mr. Calixtro, would you please raise your right hand?
Yes.
Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes.
Thank you. You may lower your hand. Attorney Ewert, you may proceed.
Yeah, Mr. Calixtro, we had a temporary orders hearing in this case on March 7th, correct? Oh, you're on mute.
Yes. Yes.
Okay.
That is correct. Sorry.
All right. And as a result of that hearing in front of Judge Lee, she made the following order, and I quote, father may have electronic video access to the children on Tuesdays and Thursdays between 7 and 7:30 p.m. Mother to provide a number for father to initiate the contact, and mother shall make the children available. Is that correct?
Yes.
Okay.
That's correct.
And that meant that your first period of phone electronic access was later that same day. Did you reach out at 7 o'clock to exercise that possession, that electronic possession?
I did, yes.
Okay. And did she make the children available?
No, she did not.
Okay. And so then the next possession would have been on March 9th. Did you do the same thing? Did you reach out at 7 o'clock and try to make that contact?
I did, yes.
Okay. And again, she did not make the children available, correct?
Yes, that is correct.
Okay. And there's been 20 periods of possession, electronic possession, since the time of that order till today's date. Has she made the children available for any one of those 20 periods of possession?
No.
And the reason is because she doesn't agree with the court's order and she's just not going to comply. Is that right?
Well, at the very beginning, she sent me a text saying that she was working, and that was like the second time I called, I believe. And after that, it hasn't been anything else. So I'm assuming that's probably why.
Okay. And so for each one of those violations, 20 violations, you're asking that she be held in contempt and fined up to $500, correct?
Yes.
Okay. And since she's not complying, you're asking the court to order some sort of bond or security to ensure future compliance of these orders. Is that right?
Yes.
Okay. And then you're asking the court order you additional periods of possession for all the, to compensate you for all the periods that the 20 periods you've missed, correct?
Yes.
Okay. You're also asking the court to award you reasonable attorney's fees in this case of $1,000. Is that right?
Yes.
Okay. Pass the witness, Judge.
Thank you. Let's see. I don't have any questions for your client, Mr. Attorney Ewert. I don't see that this associate judge's report was actually reduced to writing.
Looks well, Judge. We don't have an official temporary orders drafted by either one of the attorneys in this case, but she did reduce it to writing, and I believe sign that order on, I believe, March 21st.
Yes, that's what I'm looking at. So It is ordered that father have access and possession of the two youngest children on Sundays from 10 a.m. to 1 p.m. supervised by someone selected by the mother. And then there's some additional language about if the mother is unable to locate someone, but further, which is, I believe the basis of your client's motion is father may have electronic video access to the children on Tuesdays and Thursdays between 7 p.m. and 7:30 p.m. Is that correct?
That's correct, Judge.
Okay, so what the court is going to do, because the associate judge's report, it uses the word may. It's not actually reduced to an order, which would have that enforcement language that would allow me to actually hold her in contempt. So what the court is going to do is, well, before I say that, Attorney Ewert, did you have any additional witnesses?
No additional witnesses, Judge.
Okay, so you're resting?
We're resting, Judge, yeah.
Okay, so what the court is going to do is clarify this order. Attorney Ewert, I would like for you, as soon as you can, to reduce this to an order so we can have the a temporary order that has the contempt language in it. You know, it is ordered, shall, all of that kind of stuff. So then in the event a violation occurs from either Mr. Calicstro or Ms. Calicstro, the court is able to entertain a request for contempt, but without the enforceable language, the court cannot hold her in contempt. So that's what I would do. The court will clarify the order, so it has the enforceable language in it that these are the things that mothers shall do in order to make sure that the children are available for Tuesdays and Thursdays between 7 and 7:30 p.m. Is that clear?
That's understood, Judge.
Okay. Let me see. How soon can you get the order drafted and circulated and sent back?
I mean, I can probably get that order put together today.
Okay, so if you will reduce the entire associate judge's report to writing, that will be good. And then moving forward, if any violations occur, at least you would have the order language there. In regards to the request for attorney's fees, I can't award attorney's fees because you didn't testify to the attorney's fees. You just asked your client about the attorney's fees. You would actually have to prove them up.
Well, I understood that. I didn't, without an objection, I didn't know if that would be necessary. I mean, we can go back on the record and I can do that. And we're still here.
Well, and see, that's the thing. I asked you, did you rest and close or have any other witnesses? And you did. So testimony is already closed, unfortunately.
Yeah.
So yes, that would be the court's ruling.
Okay. I understand. All right, I'll get that circulated.
Okay, and just make sure when you reduce the order to writing on the temporary order, what I'm going to do a memorandum. So just make sure that when you draft that order as well, it reads that the respondent in this case, Melissa Calicstro, was made in default because she did not appear today.
Understood. Okay, thank you, Judge.
Okay, thank you. You're welcome.
So that's it?
Yeah.
Yes, Mr. Calicstro, you are free to leave the hearing.
Okay. Okay, thank you. Thank
You're
you, Judge.
welcome. Okay, it is 11:23. The court is in recess. The court is in recess until the next hearing, which will take place at 1:30 p.m. You all have a good lunch.